some information from the state of Florida having to deal with the work records of Mrs. Anthony, Cindy Anthony, that is, that have to deal with, it appears to be phone logs, some other type of computer-generated report, which I cannot understand, and more, it looks like about 231 pages of printouts of something that I really can't understand. I can only assume that this information is to rebut the testimony of Mrs. Anthony as to the dates. She said she may have run these searches for chloroform. However, there's still a discovery violation. The state of Florida knew back in 2009 that Mrs. Anthony was going to testify to this information, and they're waiting till right about the end of the defense case to decide to turn over these items to us. And in the event that this becomes an issue, we may need to, I don't know if we take a continuance to depose the individuals, find out what this means, how it relates to this case. And then also, these are only the records for these days. I would like to also subpoena records for other days where we know Mrs. Anthony was not at work, so we could kind of see and compare the activity between when she's at work and when she's not at work. And I think that would give us a better estimation as to whether someone can use someone else's computer or whether there are strict computer access requirements at her workplace.
Well, we'll be stopping today at 5 o'clock, so if y'all need to take anybody's deposition, you have from 5 to midnight to take their depositions tonight. But let me ask you this question. I presume that when you put Miss Anthony on the stand, you knew what answer she was going to give to the questions that you asked dealing with those computer searches being done by her, and the fact that I take it that they had previously provided you with time cards. And the state will reply, but I assume they provided you with the records that were introduced where it showed that she was at work. And then Ms. Anthony testified that, well, that doesn't necessarily mean that she was there. Right. Okay, so, isn't it sort of logical that, well, we will conduct a Richardson inquiry at the appropriate time, but my suggestion is whatever witnesses you want to talk with, y'all can schedule them for deposition this afternoon at 5 o'clock at the conclusion of the proceedings, or have them on standby so you can take them earlier if you want to see what they have to say. But it's sort of logical if someone testifies to A, somebody's going to try to see if B is not exactly true or false. So we'll do a Richardson inquiry and determine whether or not, one, this is a discovery violation, and two, what prejudice, if any, is suffered by the defense. Anything else, folks? It's that time.
That's it, Judge.
Okay. Who will be the defense's next witness?
Next witness will be Krystal Holloway.
Let's return the jury.
Krystal Holloway, Krystalholloway.
You may proceed. You may proceed.
May it please the court, Mr. Ashton. Good morning, ladies and gentlemen. Good morning, Ms. Holloway.
Morning.
Are you known by any other names?
Yes,
What name?
River Cruise.
Why do you use that name?
Well, my father used to call me River, and my mother's maiden name was Cruise.
If you could get a little closer to the microphone.
Okay, better? Okay,
Your father used to call you River, and your mother's maiden name is Cruz.
right.
Are there any other reasons why you use that name?
No,
Okay. And do you know George Anthony?
yes.
How do you know him?
I met him at a tent when his granddaughter was missing.
When?
I believe it was August maybe.
August of what year?
08, yeah,
2008?
correct.
Okay. And how often did you go to the tent?
Every day,
Okay. And did you get to know Mr. Anthony a little better?
yes.
Did you develop a relationship with Mr. Anthony?
Yes, sir, I did.
And was this an intimate relationship?
Yes,
And did Mr. Anthony go to your home or your apartment?
it was my home, and yes, he did.
About how many times did he go to your house?
Maybe 12?
And did you ever loan or give Mr. Anthony any money? Direct impeachment.
May we approach sidebars?
Okay, objection sustained. You may continue.
Ms. Holloway, did there ever come an occasion where you had a heart-to-heart conversation with George Anthony as to what happened to his granddaughter?
Yes.
Okay. Tell the ladies and gentlemen of the jury what you were doing and how that all transpired.
The particular night that you're referring to,
Yes.
he was sitting on my couch, and I was sitting on the floor, and he had said it was an accident that snowballed out of control, but I was in shock, and by the time I looked up, his eyes were filled with tears, and I didn't elaborate. I didn't ask him anything further.
Was this before Caylee was found?
Yes, sir. It was around Thanksgiving time, I believe.
And were you prompting him? Were you asking him?
No, sir.
So the topic just came up and,
Well, not exactly. We were talking about his daughter. And if I'm not mistaken, I did mention I didn't think that he can raise somebody that
well, don't give us your opinions. That's all right.
Your Honor, the witness is interrupted, and the witness needs to be allowed to finish her version of what she said to Mr. Anthony before he made the statement.
That's fine if that's, go ahead.
Go ahead. Go ahead and finish your answer.
I didn't think that he could raise somebody that was capable of harming her child. And that's when he said it was an accident that snowballed out of control. But I was caught off guard with it, and by the time I looked up, he had tears in his eyes, and I didn't say anything after that.
And how, when did your relationship end with Mr. Anthony?
I believe it was on the 4th birthday balloon release.
Okay. would that have been, do you have a date, a rough estimate of when?
Not offhand. Whenever they had the balloon release, I had attended.
When the Anthonys held their memorial for Caylee Anthony, were you still in a relationship with George Anthony?
Yes.
Okay. I'd like to show you what has been marked Defense Exhibit FT. May I approach the witness?
You may.
Before we get into that, after the relationship ended, did you go to the media or tell anybody about your relationship with Mr. Anthony prior to being contacted by police?
No, I did not.
And how were you found by police?
From what I understand,
Calls for hearsay.
Sustain.
When did the police first contact you?
2 years later, after,
And they came to you, and did they present you with anything?
yes, sir, they did.
What did they present you with?
One of the very first questions, if I knew George and if I had an affair with him.
And did they have any documentation in reference to your relationship with George?
Yes,
What did they have?
the text.
Okay. Was it just one text message or several? What was it?
Objection to discussions of items not in evidence.
He's not going into the contents yet.
How many text messages did they show you?
Several.
And did they ask you for any documentation?
Yes, sir.
And did you provide them with anything?
Yes, sir, I did.
What did you provide them with?
My phone and the letters that he had written me.
Okay. Now, these letters that he had written you, I'll strike that. The text message that you're looking at now, can you read? Oh, sorry, may I read that into the record, Judge? The
Got to offer it in the evidence. You can't read it if it's
No,
not.
I'd like
in
to, the exhibit number, reference it. I don't-
Yes, I'm sorry. Go ahead.
You're currently looking at Defense Exhibit FT. Do you recognize that text message?
Yes, sir.
Is that a photograph of that text message?
Yes, sir.
Is it a fair and accurate representation of what that text message looked like?
Yes, sir.
At this time, we would move Exhibit Defense FT into evidence, Your Honor.
No objection.
It will be received in evidence as defense exhibit numbered.
Number 72.
Can you read the date of that text message to the ladies and gentlemen of the jury and then its contents?
Tuesday, December 16th.
What year?
It doesn't say.
Okay, go on.
From George Anthony. Just thinking about you. I need you in my life.
And do you recall when he sent you that text message?
Yes, sir.
Okay, why was he sending you that text message? Objection. I'll withdraw the question. How'd the relationship end?
He was supposed to, on the Memorial Day of when I showed up, he was supposed to come over and he didn't. And then for the next 2 days, he was texting me. And I didn't think it was appropriate, seeing that I was sleeping with him, and I wasn't good enough for him to call me, and he would text me that he couldn't show up. And so when I went off crying, my sister in turn had texted him a rude message, and I never heard from him again.
And did he attempt to go to your apartment complex or your condominium complex?
When?
around that time, in December of 2008.
Basis of knowledge, hearsay, referred to attempt, so.
Okay.
If she's aware.
Well, she could be aware of hearsay.
Wait a minute, gentlemen. Establish a foundation for a basis of knowledge. You
Yes,
may
sir.
continue.
Is there a guard gate, a guard post at your complex?
Yes, sir.
Okay. And did you have to instruct the guard at the gate not to let him in your complex anymore?
Objection. Relevance?
Overruled. You can answer the question simply by yes or no.
Yes, sir.
Now, after the police had found you, did your name become exposed in the media?
Yes, sir.
Okay. And what happened?
I'm not sure what you're asking.
Were you beginning to be harassed by the media?
Yes, sir, I was.
Relevance.
Sustain.
And I'd like to a little leeway on this so I can tie it into something that I think we
Sustain.
May we approach so I can
Yes,
talk
sir.
into the court?
You may. You may proceed.
When the police first asked you about the affair, did you deny it?
Yes, sir, I did.
Why did you do that?
Because I felt that he would get in trouble, and in the manner that it ended, I just assumed that the media would find out about it if I told the detectives. And so I initially lied because I was embarrassed.
Were you also in a relationship at the time?
Yes, sir, I am. That's correct.
Were you when you told that to the police?
Yes, sir.
And were you when you were seeing Mr. Anthony?
Yes, sir.
And did you eventually tell the police after the initial time that you did have a relationship with him?
Yes.
Hearsay.
Overruled.
Go ahead and answer.
I'm sorry.
Did you eventually tell the police the truth?
I did tell him the truth.
And was that after being confronted with all of the other text messages and information?
Objection leading.
Sustain.
When was that?
I'm sorry.
When did you finally tell them the truth?
I had no choice behind the texts.
When you say that, you mean you were confronted with it?
Correct.
Now, after this, prior to the police finding you, and subsequent to that, your name was released and all the information came out, did it not?
Yes.
And after that, did you then sell your story to a tabloid magazine?
No, I did not.
Okay. Did you give an interview?
I did
to
give
the
an
Inquirer?
interview.
Okay. What happened?
Well, the gentleman that did the interview offered me the chance to tell my story in full because the media, he said that the media would edit.
Hearsay.
Sustain.
Just tell us why you did it.
I felt that the media would edit certain things and make me look like trash. And he gave me the chance to tell my story in full.
Okay. And do you have a twin sister?
Yes, sir, I do.
And as part of that interview, you got compensation, or your sister got compensation.
Correct.
Are you here testifying truthfully?
Yes, sir, I am.
I have no further questions. Did you want to come here and testify today?
Yes, I did.
Why?
Because
Objection to relevance of why.
Sustain.
I have no further questions.
Cross-examination.
Ms. Cruz, at the time that you inserted yourselves into the Anthony's lives, they were already celebrities, weren't they?
I don't think they were celebrities.
Well, they'd been, go ahead, I'm sorry.
They were looking for their granddaughter.
They had been in the news.
Correct.
They had been on national news.
Yes, sir.
They were on the news almost every day.
Yes, sir, they were.
And then you sought them out, correct? They didn't come to you, you sought them out.
That's correct.
Now, how much money did you or some member of your family get from the National Enquirer for selling your story?
$4,000.
$4,000. And that was just for talking to them.
Yes, sir.
Now, did other news organizations that don't pay for interviews request interviews from you?
As well as the ones that do.
And you chose the National Enquirer, which pays for interviews. Correct?
Yes, sir, but he had given me the chance to explain everything in detail, unlike the news media that edit things.
And you felt that the National Enquirer was the one news source that you could trust to tell your story and not sensationalize it. Is that your testimony?
Sir, I took what I could because I was being trashed in the media as it was.
And you felt that the National Enquirer was the one place where that would tell your story in a fair, honest, and non-sensational way.
Well, he did.
Overruled.
He did tell it.
He told it the way you wanted it told.
No, sir, I told it the way it happened.
And the story is much, much better if you're actually having an affair with George, right? It's much more sensational.
I did have an affair with George.
But you would agree that the story is much sexier if you're actually having an affair with George than if you're just a friend.
That's not true.
Judge, argumentative.
Overruled.
So you do not agree that in your perception that this story is better if you're actually sleeping with George Anthony.
That's not true.
Now, you indicated that George also sent you letters.
Yes, sir.
If I may have it. Let me show you State's Exhibit RS. You recognize this as as a letter that you referred to in direct examination, one of the letters George sent.
Yes.
And that was sent within a couple of weeks of the text message that counsel was just asking you about.
Yes.
Thank you. You give it back. Now, at this time, I'm moving to evidence. State's Exhibit RS.
What says the defense? Let me see it in basis of objection.
I'm sorry?
He said it was the defense's case. Objection sustained. Just You may proceed.
Thank you. Ms. Cruz, in early January of 2008, you received a letter from Mr. Anthony which referenced his attempts to leave messages
Let me hear the question.
with his
Ms.
attempt,
Cruz, don't answer the question until I tell you to answer it.
Yes, sir.
All right,
with
go
his,
ahead and ask your question.
his attempt to leave messages for you through your daughter, through security, and also through your husband. That's the question.
Mr. Baez,
Objection to referencing an item that's not in evidence, Judge.
overruled.
Isn't that true?
I'm not married, sir.
Did he send you a letter which referenced attempting to get messages to you through your daughter, security, and someone he referred to as your husband?
Yes, sir.
Were you in a relationship then?
Yes, sir.
Did Mr. Anthony believe that person to be your husband?
I don't believe so.
Did you reference this person as your husband?
I don't believe so, no.
Do you believe that Mr. Anthony thought he was? I'm sorry, you're right. I withdraw. I withdraw.
Sustained.
Did you ever do anything that would lead Mr. Anthony to believe that you were in a relationship with this other person, which was similar to a husband-wife relationship?
Yes, sir. He knew I was.
What did you tell him?
He knew I was in a relationship with someone else.
Now, did he also, in that same letter, reference your friendship with him and his wife as being very personal to them?
Yes, sir, he did.
And in fact, did he sign the letter from,
Referring to an item and its contents that are not in evidence.
The question is phrased to be sustained.
did he send you a letter with reference as being from both himself and his wife?
Judge. Same.
Overruled.
Yes, sir, he did.
The time that that text message that counsel pointed you out was sent 5 days after George Anthony learned that the remains of a small child had been found approximately a quarter mile from his house.
Yes, sir.
Now, you will acknowledge that you recall giving a statement to law enforcement on February 17th of 2010.
Yes.
And in that statement, you were placed under oath. Is that correct?
Yes, sir.
And you swore that the information you give today was going to be true.
Yes, sir.
And you were asked in that statement, let me have just a moment, if you were in a romantic relationship with George.
Proper impeachment.
Overruled. You got a page number?
I will get that for counsel. Just a moment. Page 11, line 2 through 7. You were asked the following questions. Question. Were you, please excuse the question, please forgive me, rather, did you and George become romantically involved? You answered, no, we didn't. The question was no, and you affirmed no.
That's correct.
That is the statement you gave under oath.
Yes, sir.
When is the first time that you claim you altered that statement? In other words, that you told someone either in the media or in law enforcement that that was not true?
In February, when I told the detectives.
Well, this statement was given on February the 17th of 2010.
That's correct.
And when did you then change that?
My sister had went to the media with it, and when it started coming out, I spoke to the detectives, and then I told them the truth.
When?
Within a couple of days that they had first initially came to my house.
After your family went to the media?
No, sir.
I'm sorry, I thought you just said that your sister went to the media.
She did.
Well, isn't she your family?
Yes.
Okay, so after your family goes to the media with this story, then you call the police and change it to,
No, sir.
do I have the chronology wrong?
Yeah.
Go ahead.
I spoke to the detectives, and I told them the truth, that I had been sleeping with George.
When?
Within a couple of days when they first found me.
Okay, well, they found you on February the 17th. And you said, yes, February the 17th. You said the next day your sister went to the media.
No, I think it was by the end of that week.
Okay. You recall what day of the week the 17th was?
I'm sorry?
You recall what day the 17th was?
No.
Right. So your sister goes to the media with this story. When does the National Enquirer first contact you or any member of your family?
I don't remember.
It was very quickly after that, wasn't it? Not for the date, Judge.
I don't know the date.
Overruled.
Well, tell us how the contact from the National Enquirer or other media sources, how that related to your changing your story about the romantic relationship.
I had no choice but to tell the truth because my name had already came out.
Well, I mean, you had no choice but to tell the truth on the 17th because you swore you would, but you lied.
Yes, sir, I did lie.
So what we're trying to figure out now is when this change in the story took place and how.
Within that same week, when I first initially spoke to the detectives.
And that was about the same time you were talking to the media and selling your story to the National Enquirer.
No, I did not. And no, I did not speak to the media. I wanted no part of it.
When did you first discuss giving media interviews to the National Enquirer?
Possibly the end of the week, sir.
Now, let's get to the statements that you claim that George made. What you were talking to him about his daughter and how you couldn't believe that he could raise a daughter that would deliberately kill her child.
That's correct.
And what he said to you is, I really believe it was an accident that just went wrong.
Objection,
Isn't that
Judge.
true?
That misstates her statement.
It does not.
It does, Judge.
Well,
That's not what
gentlemen,
she
approach the
testified.
sidebar and bring me the statement. Objection withdrawn. You may proceed.
What he said was, I really believe that it was an accident and it just went wrong and she tried to cover it up. That's what he said.
No, he did not.
Do you recall, again, in your statement to law enforcement on that same date we have discussed where you took an oath to tell the truth, for counsel's benefit, page 16, line 25 through page 17, line 1. May I approach the witness?
You may.
Would you please read to the jury what you said at page 16, line 1, and then complete it on page 17? Read it out loud.
He just said that I really believe that it was an accident and it went wrong and she tried to cover it up.
Thank you. Is that, in fact, what he said?
Yes, but he also said that it
Ma'am, there's no question before you.
Witness be allowed to finish her answer.
She is not finishing the answer. She's adding additional information.
Ma'am, finish your answer.
You didn't read what was above that was highlighted? He also said it was an accident that snowballed out of control.
Now, did he also tell you, he didn't tell you that he was present when this occurred, did he?
I'm sorry?
He didn't tell you that he was present when this occurred, did he?
When what occurred?
When this accident occurred.
No.
In fact, he never told you that he knew it himself, that he knew that to be the case.
I just told you that's what he said. I never elaborated to anything else. I
What's
never
the-
said that he said anything else other than what he said.
Other than he believed it was an accident that snowballed out of control and she tried to cover it up. That's all he said.
That's not what he said. He said it was an accident that snowballed out of control.
But he didn't claim that he actually was there or knew that.
You're right. I agree with you. He didn't.
He said he believed it.
No, he did not say he believed it.
Now, he didn't say that he knew it, and he never said that Casey said it.
No, sir, you're right.
He also told you on another occasion about an incident involving, just a moment if I may. Was there another incident he relayed to you where he had talked about attempting to get information about the death of Caylee?
I don't know exactly what you're referring to.
Did he relate to you an incident where he, quote, threw his daughter Casey up against the wall, choked her?
Goes beyond the scope.
Your Honor, under 90.806, it is an inconsistent statement.
That's not true. Judge.
Sustain.
Your Honor, could we approach?
You may. Objection sustained.
No further questions. I'll return.
Redirect.
Ms. Holloway, the statement that Mr. Ashton read to you about you saying he believed when the statement in reference to Mr. Anthony believing that it was an accident. Do you remember that line of questioning?
Yes.
Okay. And before that, well, let me rephrase that. You had actually, that statement was taken out of context, was it not?
Yes.
Okay. And in fact, before in that line of questioning, you had said, may I approach the witness?
You may.
Before you had said what?
That he said it was an accident that snowballed out of control.
So we're clear on that point. That's a statement you made first, and then you followed it up with the statement that Mr. Ashton tried to have you read without expressing
Objection
that.
to comments on counsel. Move to
Sustained.
strike.
Let's just ask the questions.
Yes, sir. Now, this was also a statement he made when he was still out making media appearances asking for help to find his granddaughter.
Yes, sir.
And he told you basically that she was dead.
Objection to her interpretation of what Mr. Anthony said.
Sustained.
He told you, while he was telling the world that she was missing, he told you it was an accident that snowballed out of control.
That's correct.
And he was also having this, the text message that we referred that Mr. Ashton pointed out was, I guess, 5 days after his granddaughter was found. You were still having a relationship with him while this was going on, were you not?
Yes.
Okay. And for 2 years, you did not go to the media or tell anyone that you had a relationship with George Anthony.
Objection leading.
Sustained. Rephrase the question.
How long was it that you kept quiet about your relationship with Mr. Anthony?
Objection assumes the fact not in evidence that she kept quiet about anything.
Overruled.
2 years. I never went to anybody. They came to my door 2 years later,
Who came to your door?
the detectives.
And after this happened, after the detectives came to you, the relationship was exposed.
Yes, sir.
And it came out in the media.
Yes, sir.
Okay. And your actions afterwards was for what? Why did you go to the Inquirer?
Because I didn't want it to be edited. I was told that if I went and did an interview with the media, it would be edited, and he gave me the chance to tell my story in full.
And was the media telling your story in full at that time?
No, sir?
Were they saying all kinds of negative things about you?
Yes.
I've
That I have a criminal background. I do not,
Okay.
and I believe they know that.
Now, you have had issues where you had a failure to sign a citation.
Objection. Relevance.
Sustained.
No further questions.
Recross.
Yes, sir. For context, may I approach the witness? Ms. Cruz, I want you to read to the jury the portion that I had you read before and then the following question and answer. So start right here and read to the end of line 9 of page 17. So the jury has the context. Read the whole thing, starting here, all the way through.
Do I read everybody else's remarks?
Yours.
Just a
mine?
second. What is she reading?
This is her statement, referred by counsel, page 16, line 25, through page 17, line 9.
And what is the date of the statement?
I'm sorry, Your Honor. Yes, February 17th.
And Mr. Baez, your objection, sir.
It's a document that's not in evidence.
Overruled.
Okay, so start with the part I had you read before, and then read the
Do you-
next few questions and answers.
Do I read everybody else's remarks?
Yes.
Okay.
Read the whole thing, so the jury can hear you. Let me pull this over so they can hear you. Go ahead.
He said, I really believe that it was an accident and it just went wrong. And then she tried to cover it up. Casey, no verbal response.
May I see?
Did,
Hold on a second.
Pardon?
Mr. Ashton referring to, because that's not putting it into context.
Take a look.
It's not being read into context, Your Honor. In fact, the first statement that was referred to is on this fact.
Let me see.
Okay, if you would start at the top of
Just a
this.
second.
I'm sorry.
You may proceed.
Start at the top of this page, read every question and answer until you get to page 17, line 9. And just read it out loud.
did he tell you what he thought happened to the child? Yeah. What do you say? Upset. Krystal, it's okay. We have to know the truth about that. It's important. He said that, sorry, it's all right. Take your time. He said that it was an accident that went wrong and it snowballed. I'm sorry, and it just snowballed. And he said, you know, how you tell a small lie, and he just tried to cover it up. And it just got really it got really big and it just went out of control. Did he explain to you? Did he give you more than that? No. What type of accident? Because he was sitting on a couch in my house. And I was sitting on the floor, and I understood that because I've done and said so many things in my life that I was ashamed of, but I never thought I would escalate to something so big. When did that conversation occur? Remember? I don't remember exactly. I think it was the last time he was at my house. And that would be on the gate that would have the information at the gate. But he didn't give you specifics. He just said that. I really believe that it was an accident, and it just went wrong, and she tried to cover it up. Casey, no verbal response. Did he say to you that Casey had told him that this was an accident or this was something that you had just believed? He didn't say that. He said, like he knew it was inaudible. I don't remember him saying, like Casey said it. He just said it was an accident that went wrong.
So they specifically asked you whether he said he was told about it or it was something that you believed,
And answered.
Overruled.
and you told them he didn't say that. He said like he knew. So George made it clear to you that he did not have any firsthand knowledge of what happened to his granddaughter. And that was the context of what he said, wasn't it?
Judge, that misstates the statement. The statement reads for itself, speaks for itself.
Overruled.
Correct.
Thank you. No further questions.
Redirect.
Ms. Holloway, you made the statement in here that he didn't say Casey told him. He made it sound like he knew that it was an accident that
Objection.
snowballed out of control, correct?
Objection, leading.
Rephrase your question.
Did he say Casey told him? Is that what you wrote? Is that what you said here?
Yes.
Okay. You didn't say Casey told him.
Right.
Okay. And what you conveyed to the police is that he knew that it was an accident that snowballed out of control.
Objection, leading.
Sustained. Rephrase your question.
Did you tell the police that he knew it was an accident that snowballed out of control?
Objection, leading.
It's not a
Yeah.
leading question.
She can answer the question.
I'm sorry.
Did you tell the police that he knew that it was an accident that snowballed out of control?
That's correct.
And after he left your house that day, he made further appearances asking for people to look for his live granddaughter.
Of cross.
Sustained.
No further questions.
Can I have the statement back? Ms. Holloway, I'm quite frankly confused. You,
Sustained. Ask your question, Mr. Ashton.
sure. In the statement, you said he didn't say that like he said, like he knew. That is what you said,
Yes, that's exactly what I said.
and that is what you intended to say.
Yes.
Thank you.
May the witness be excused. Yes, sir. You may.
Oh, Judge, could we approach appears to be a different statement?
You may.
This is what was brought
Why
up.
don't we do this? Members of the jury, I'm going to let you go for your recess, short or special. Okay. 5, 10, 15. We will be in recess to 10:30. Thank you. And y'all can stay wherever y'all are. Ma'am, you can stand down to 10:30 and take a recess. Huh? Okay, gentlemen. You don't get both. So if y'all want to clear this up, jurors coming back in 10:30, so talk as long as you want to talk. But let's clear this up now. So then you can go take a recess whatever time you have left.
Yeah, I was just going to go grab some out of the room there to clear it.
Okay, go ahead. Okay, have y'all straightened out your differences with the statements?
I haven't received a copy of it yet. It's my understanding it's from a different date, and I didn't have a chance to.
Judge, I'm not gonna ask the question. I have no further questions, so I think she'll be done.
That'd be fine.
Okay, Mr. Ashton, you had a requested instruction?
Yes, I provided it to a council table. The request that this instruction be read to the jury now that the witness's testimony is over. It reads as follows. The alleged statements of George Anthony testified to by this witness may be considered by you only as they might impeach the credibility of the other testimony of Mr. Anthony and for no other purpose. These statements may not be used as any proof of the manner in which the victim in this case died. I believe that is in accord with the authority I've indicated in the attached to the instruction, that since this alleged statements were not under oath, then they can be used only for impeachment and for no other purpose.
Mr. Baez?
Who objects to that? Currently influencing cases right now, Judge.
I'm sorry?
You need to be at a microphone if you want it on
Yes,
the
sir.
record.
We would object. I think that we're pulling some cases actually right now to be able to argue this point, but as presented, I think that goes a little farther than what the proper instruction should be, if the court feels that one is necessary.
Well, are you familiar with the case of Pierce versus State, a 2004 decision of the Florida Supreme Court found at 887 second page 561, which gives a pretty good dissertation on prior inconsistent statements, even quotes the Bible on evidence, Professor Earhart's book, and I think the statement that she gave was a statement to law enforcement. Is that not correct?
Yes, I don't have a copy if I can see.
You can look at mine, but I put one on the table there.
Let's see when they just.
Well, let me go over it.
In the case that
I think the statement should end after no other purpose. Because the rest is just argument at that point.
The reason I put that in, Judge, is because in the particular context of this case, that is the single and only piece of evidence that this jury has heard to suggest that this child died as a result of an accident. So it may be fine to tell them that, but in this particular case, it needs to be emphasized to them that it cannot be used for that purpose. A general instruction they might not understand. Sure, I could argue it at the time of the closing argument, but they need to know right now that that statement is, and it is a correct statement of the law, that statement is no proof of how this child died. So I would ask the court to give a more case-specific instruction of some sort.
That is, it's argument, it's additional surplus verbiage that is unnecessary, especially after saying for no other purpose. In addition to that, just because Mr. Ashton says that that's the only piece of evidence that's been admitted as to an accident doesn't make it so. I think that there has been numerous other points made on that topic, but that's irrelevant to the issue other than Mr. Ashton deciding to argue. And that's what this is, just more blah, 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 blah. And
have you read the case that Mr. Ashton cited, the Dudley case by the Supreme Court of Florida on this particular issue where, memory serves me correctly with the Dudley case, the state got a conviction in a first-degree murder case, and the defendant was sentenced to die, and it was reversed because the state used the inconsistent statement as substantive evidence.
Well, I think this, if the court's going to grant this instruction, that would preclude that.
What would preclude what?
This being used as substantive evidence. It is here to.
You're not alleging that it is, are you?
I am what? I don't understand.
So you're not saying that the statement that Mr. Anthony, that she said Mr. Anthony said about this being an accident, you're not saying that's substantive evidence, are you?
No, Judge. What I'm saying is it is to impeach him. So there it is. The very first sentence is what it covers. The alleged statements of George Anthony testified to by this witness may be considered by you only as they might impeach the credibility and other testimony of Mr. Anthony and for no other purpose. What do we got to say it 3 times? It's said twice there.
The difficulty in the context of this case is that the significance of this statement isn't really to impeach George Anthony. And we all know that this statement was put before the jury not to impeach George Anthony. George Anthony has been impeached a lot and more than adequately on many different topics. This statement is put before the jury in hopes that they will take it for more than it's supposed to be. And that is why, with all respect, Your Honor, I would submit that there needs to be a more directed, case-specific instruction by the court to make sure that there's no possibility that this jury will use this piece of information in an improper way.
I think that the court, when you say for no other purpose, is being very clear. And some of these instructions are phrased in a way that might let the jury believe that somehow this court, when reading instructions, feels one way or another. And I think that every instruction needs to be fashioned in a way that is presented to outline the law as this jury is to follow it. But to go on and allow the prosecution to make argument and add that on, which is all this is its argument. And at what point do you stop? You're saying it twice. This is a 3rd time. Why not a 4th or a 5th? It's surplusage. It's certainly too much, and for no other purpose ends it right there, Judge. It's to impeach this person. The line of cases under Pierce all are that the court should give an instruction sufficient to be able to explain to the jury what is the purpose of this witness's testimony. That's what it is. End of story. The prosecutor doesn't get to throw in a jab there while they're at it. And that's our purpose. That's our point.
Okay. It is quite evident that an instruction needs to be given. We have 2 trained lawyers who can't even agree as to what the law may be or may not be. And how do we expect this jury, who are not trained lawyers, to digest this and how to utilize the testimony? Pursuant to Williams versus State, 443 7th 2nd 1053, a 1984 decision of the 1st District Court of Appeals, pursuant to the case cited by the state of Florida, Dudley versus State, 545 7th 2nd 857, a 1989 decision of the Florida Supreme Court, and pursuant to Pierce versus State, a 2004 decision of the Florida Supreme Court found at 887 2nd 561, the court will give the following amended instruction. Just a second.
May I add one more point, Judge? Unless it's already written. I'd like to just lay out something clear.
You have anything? This is the instruction that I propose to give. The testimony concerning the statements of George Anthony testified to by this witness, Krystal Holloway, may be considered by you only as they might impeach the credibility of the other testimony of Mr. George Anthony, and for no other purpose. These statements may not be used by you as any proof of the manner in which the victim in this case died, and that you are not to use that testimony as evidence of the defendant's guilt or innocence.
Your Honor, I would disagree with, I would object to that portion. In fact, I think what the court is doing is just telling the jury, don't even pay attention to this witness's testimony because it's not important. And this is not necessarily an accurate reflection of what this witness might be able to accomplish with this jury. And let me explain. What the jury may infer if they decide to believe Ms. Holloway over Mr. Anthony is that he lied on a specific topic, which is the purpose for this testimony, to impeach him. The jury then can decide, based on that lie, on that specific topic, to use that towards the guilt or innocence of Ms. Anthony. It does play a factor. We're not putting on witnesses on the stand for no reason. So I think by putting both of those sentences ahead, it diminishes what this witness testified. The jury should be instructed that, yes, it's brought in for impeachment purposes only and no other purpose. But to take it a step further, as both the state and the court want to do, it takes it to the level of basically instructing them to disregard her testimony and what it means. What it means is he lied. And at that point, they can determine what that means as it relates to Mr. Anthony lying. And these two, the two sentences that were added, I think put us in a worse position.
The First District Court, in its opinion in Williams versus State, authored by Judge Jonas, said the following: as a court's witness, Henderson was subject to impeachment by the use of prior inconsistent statements. Before Officer Bridges was allowed to testify before the jury, the trial judge instructed the jury that his testimony was to be used for the limited purpose of determining Henderson's credibility, and specifically instructed them not to use the testimony as evidence of Williams' guilt or innocence. Given the limiting instruction, the trial court properly allowed the prior inconsistent statements to impeach Henderson's credibility. A couple of things you said are precisely what impeachment is utilized. The jury will be instructed that they can believe or disbelieve all or any part of a witness's testimony. They will be instructed that they can consider whether or not a witness gave inconsistent testimony. So they can believe what they want to believe of Mr. Anthony or any other witness that may have been impeached. To not instruct this jury, who are not lawyers, and we've clearly seen here today that even the lawyers can't agree on what the law is and what the law means. Rightfully or wrongfully, I am charged with that responsibility, and if we get to that stage, my paper will be graded. So I will give the instruction as modified based upon the authority that I have previously cited. Anything else before we bring this jury back in? And I take it that, is anybody going to else ask Ms. Holloway any other questions?
No.
Okay, we'll bring her back in, put her up here, and then I will find out whether or not you're going to ask any questions, excuse her. We'll excuse her in front of the jury. I will instruct them afterwards. And who will be the defense's next witness? Okay. All right, let's bring Ms. Holloway back in, place her in the witness box. State recognized presence of jury,
Yes, sir.
defense,
Yes, sir, we do.
and members of the jury. Did you heed all of my previous admonitions during the recess? Okay, any more questions, Mr. Baez?
No further questions, sir.
May the witness be excused.
Yes, sir.
Thank you, ma'am. You may be excused. Okay, ladies and gentlemen of the jury, I have the following instruction to give you. The testimony concerning the statements of George Anthony testified to by the witness Krystal Holloway may be considered by you only as they might impeach the credibility of the other testimony of Mr. George Anthony and for no other purpose. These statements may not be used by you as any proof of the manner in which the victim in this case died, and they are not to be considered to use, and you are not to use that testimony as evidence of the defendant's guilt or innocence. Thank you. The defense may call their next witness.
Defense calls